I
Morning.
want to welcome you all this afternoon. I hope you're having a great day so far. We had a great workout this morning for those of you that joined us on our Move and Groove. For some of you are new to our online classroom. This is the online Edgemont classroom. It's our virtual senior center, and we are. I think we started this. I want to say the beginning of April. So we just started our mill registration for the summer semester, and it looks like we will be continuing virtually into the fall. But I appreciate all of you learning how to do Zoom and continuing to stretch your chops, so to speak, on technology. It's a bit of a challenge for some of us over the age of 14. My my son is really good at it. So I feel like with my son home, I have a built-in tech support. But anyway, we had the honor and the privilege of partnering with a great company called Home Watch Caregivers, and since so many of you are home, it's sort of a perfect pairing in a way. And so, without further ado, I am going to introduce to you Randy Brockman from Home Watch Caregivers.
Thank you. Thank you. So I'll just give a little bit of our background. This workshop was originally scheduled to be at Edgemont in March with Eric Goldberg as your speaker. And the way it came about is that I did a program from Home Watch Caregivers in South Orange, and I did a program on the services of needing help in your home, and there were lots of very interesting conversations. So I'm just going to say that, especially now, stay home and stay safe. They were very powerful directions to save lives in this COVID new world that we're living in. But what about your loved ones, or what about the elderly, or what about someone who had surgery? They're vulnerable and they're isolated in their homes, and especially without the ability to be with friends and family, this isolation has taken an additional emotional, physical toll on people. And that's where Home Watch comes in. So just say that if you are worried about your loved one in their home or in a senior facility, we can provide the necessary compassionate care. We've been doing it despite this time. I always say that our company has always been involved in good care, and that we feel like it shouldn't interfere with the quality of life. We have a reputation as a high high touch provider. Today that doesn't sound so great, but when I say high touch, it means our nurses and our social workers who are overseeing the care of our clients. They do it on a very individual basis, knowing that each of our clients are unique. We have 110 caregivers who have been with us, all of them over 1 year, and we're actually always taking on new and quality caregivers. We believe that they are the frontline workers in today's society, and we take good care of them, so they take good care of our clients. Now, what's happening in our world today is that so many people have not been prepared for home care. They haven't been prepared for taking care of their future. And when I did my workshop at Edgemont a few months ago, or many months ago already, I realized that there were so many questions that were legal questions people were asking. And I said, let me bring in a specialist who can help you with this. So that is why we have today our specialist, Eric Goldberg. He's with Mandelbaum, Salsburg, and he's going to speak to you about preparing for situations and making sure that your paperwork is in order. He is a co-chair of Mandelbaum Salzburg's Elder Law Department. He has many years of planning and collaborating with clients, professionals involved in the caring of the needs of seniors, special needs adults, children, and veterans. And we're really pleased to have him here today, as well as his co-worker, Amy Neely, who has been a wonderful friend to me over the past few months. So we welcome you and thank you for spending the time with us today.
I am Eric Goldberg. Thank you very much, Randy, and thank you, Michelle, and thank you, everyone, for joining us today. It is really, to me, inspiring that everybody is embracing this technology. It hasn't been around that long, and it's obviously, as everyone can see, because we've been doing it for the last few months, we've been using Zoom technologies and other video communication tools, that this is the future, or actually I should say this is the present now. So I'm just so glad to see that everybody of all ages is beginning to embrace it, because it's soon going to be just like using the telephone, I think, even when there is no pandemic, which hopefully we'll find out soon. But it just makes everything so much more powerful. For instance, we always had difficulty scheduling seminars for people because, for instance, if we wanted to go to an assisted living facility to schedule a seminar, there would be people at work, there would be people who wanted to eat dinner, and all different, everyone has a different schedule. But now in today's day and age, now that you've embraced this technology, you can see educational content anywhere, pretty much at any time too, since it's recorded. So many years ago, I started compiling mistakes that families were making during a long-term care need or in preparation of a long-term care need. And I put them all into this PowerPoint so that I could let others know that these, what people think maybe are not important, can become very important when you're planning for a long-term care need. So I always start with the Rolling Stones. And the reason I start with the Rolling Stones is because they are seniors. And, when I was young, they seemed like old people to me then, and they're probably younger than I am now. And when you were young, these are the type of people that your parents are probably warning you against. But they're in their, I think the youngest Rolling Stone is now 74. So it's highlighting the fact that the population is getting older. And so you're not alone. One of the biggest mistakes that we find families making when they have a senior loved one in the family is that they give their house away very often to their children, thinking that that's a great way to protect that house. And very often they give it away not knowing why. They just do it because maybe they found out that their neighbor or their best friend transferred their house to their children, and no one ever really told them why. One of the main reasons that people would do that is because they want to protect it from Medicaid. And what they say is, we don't want either Medicaid or the nursing home to take this house from me. And so let's protect it by giving it to the children. So I use this as the first slide and the first cautionary tale. Do not do this. There's almost never a good reason to do this. And I'll tell you why. I like to say that elder law is like a Rubik's Cube, if you remember the Rubik's Cube. So when you move one side, the other side changes. And so what happens here is, if you move your house to somebody else, you give it to them, the deed changes, they now own title to the house. You have actually done one good thing. You have removed it from your name for Medicaid purposes, but you've created a whole litany of other problems, some of them potential problems and some of them certain problems. So what are the potential problems? Well, what if the person that you transferred it to, who now owns it, gets divorced? Well, their spouse is going to say, hey, half that is mine. What if the person you transferred it to gets into a horrific car accident and is now sued above and beyond what their insurance will cover? That asset is theirs. What if that individual is sued because they have financial problems? I've seen that happen in my own family. Or what if that individual dies before you? Now that house is subject to either their will, or if they don't have a will, to wherever New Jersey wants that house to go. I've actually seen and it sounds funny, but it's not, a parent give the house to the child dies, and without a will, and by the laws of intestacy in New Jersey, the house goes back to the parent. And then the parent's on Medicaid already. So that happens. These kind of things happen all the time, unfortunately. Those are potential problems. Here are the certain problems that could happen. When anybody owns a home, their primary residence, and they sell that home during their life, they get a $250,000 capital gains exclusion. What does that mean? It means that if the house is increased in value, the first $250,000, there's no tax owed. If they're married, it's $500,000. But if you give your house away to your children, and then you want to move, let's say you want to downsize or you want to move into assisted living, that somebody else owns that home and it's not their primary residence. You cannot take that $250,000 or $500,000 capital gains exclusion. So I'll give you a quick example. Let's say you've owned the house a long time and you bought it for $100,000. You're selling it for $600,000. So now there's a $500,000 gain in that house. Under the IRS rules, if you own that house, it's your primary residence, that $500,000 capital gain is wiped out. You don't pay any tax on it. But if you've transferred it to a child and you want to sell that house, and it's actually the child that's selling it, they're going to pay between 25 and 30% in tax. Almost $150,000. That's a big mistake to make. So we have to be very careful about transferring homes. Same thing if one dies with owning property. I don't know if anyone saw presidential candidate Biden yesterday announced that if he were president, he might do away with what's called the step up in basis. Step up in basis is actually a very important law, and it's been around for a long time. The reason he wants to do away with it is because without step up in basis, the government will be able to recoup a lot of the taxes. When somebody dies nowadays, their heirs receive what's called a step up in basis on any of their assets. So let's go back to my example. If you purchase your house for $100,000 and you die owning that house and it's worth $600,000, the step up in basis rule says, well, it's not, you didn't buy it for $100,000. You actually bought it for $600,000. So when your heirs sell it for $600,000, they don't pay any gain. But once again, if during your life you gave it away to a child and it's worth $600,000, the government says, wait a second, you paid actually $100,000 for it because you got it for free. Or they may even say you paid nothing for it because you got it for free. And now there's a $600,000 gain. And once again, they're going to pay an enormous capital gains tax on that. So that's the most complicated slide today, but it's one of the most important. And I spend a lot of time undoing this particular mistake. One of the ways that we do protect a home, by the way, for Medicaid purposes, is we recommend moving it into a special type of trust. And that's what we do in my practice. Second mistake is that people assume Medicare is going to pay for their long-term care. Well, Medicare is a program that every senior over 65 gets anyway. It's an entitlement program. It's not a program that you have to be approved for. And Medicare covers hospitalization. It covers sometimes prescription drug costs, and it covers up to 100 days in a rehabilitation facility. The reason that many people think Medicare pays for long-term care, and when I say long-term care, I mean care in a nursing home or sometimes care in an assisted living facility with a high level of care, usually in a place that somebody's going to pass away in. number one is because Medicare and Medicaid sound similar. But number two is that if you've ever spent time in rehab, let's say you broke your hip, you broke your leg, or something, or you had pneumonia or something where you had to get back on your feet again, well, where are those rehab facilities? They're oftentimes a wing of a skilled nursing facility. So people start assuming that, oh, well, Medicare paid for my stay there. They would continue paying. And what happens when people assume Medicare pays for their long-term care? They don't do Medicaid planning. Medicaid planning requires at least 5 years in order to safely transfer assets into a trust, usually, or it could take less time, and those are usually crisis cases where we can use certain legal strategies to get somebody on Medicaid earlier. The problem is that once one runs out of money, the strategies disappear. And now the family's left scrambling to figure out how to pay for somebody's long-term care. Okay, next slide. People do this all the time. So they deny there's a problem, or they assume that they're just going to die in their sleep. And so they neglect to sign a power of attorney. If you take nothing else away from this presentation today, make sure that you have a financial power of attorney and a healthcare power of attorney. Without those, you will leave your family potentially scrambling to assign or to get appointed a guardian to make decisions for you. Not much can happen without a power of attorney or a guardianship. So I'll briefly explain what the financial power of attorney and the healthcare power of attorney do. A financial power of attorney appoints an agent to take care of all of your financial affairs, whether you are incapacitated or it's merely more convenient for them to take care of that. What we do 99% of the time is we do immediate and durable powers of attorney. Now, some people get nervous and say, wait, I don't want to give somebody the right to administer my finances while I'm still well. But the issue here is, what if you are mentally okay? You can make your own decisions cognitively, but you're temporarily or permanently unable to do certain things. So some people are in bed and they can't speak for some reason, and they need to talk to their credit card companies, or they need to talk to their utility, or they need to pay bills, or they need to sell their home. And that's oftentimes the problem we have, is we need to transfer property and somebody can't transfer the property. So that's what a financial power of attorney does. A healthcare power of attorney, on the other hand, is only for healthcare decisions. And while the power of attorney is available to you if you're not incapacitated, the healthcare power of attorney is only available if you cannot make your own decisions. And those decisions might be admitting you to a hospital or a nursing home or a psych ward, or maybe to consent to a surgical procedure. So imagine you slip on ice, you're knocked unconscious, and you're taken to the hospital. The emergency doctor says, you know what, this individual needs surgery to repair her hip. Well, without somebody to consent to that, they can't do anything. They're legally not allowed unless it's a true emergency. Now, obviously some hip surgeries are true emergencies, but sometimes the doctor says, you know what, she'd be better off if we do surgery than not. She may never walk again if we don't do surgery. They need somebody to authorize them to do that. So two very important documents. The healthcare power of attorney oftentimes includes a living will, which states in short, in the event that my death is imminent, I do not want artificial means keeping me alive. Okay. let me just see something here. If I can get, okay, so there are three. Okay, so people are just saying, okay, so if you look at the chat, I don't know how familiar you are with the chat, but there are three dots usually that say more. I think on your screen it's going to be on the bottom. If you want to ask any questions, you can ask them in the chat or you can save them for later. Okay. Okay, so Sandra raised her hand. Michelle or Randy, can you unmute Sandra, or Sandra, do you want to type in the chat?
I'm sorry, that was a mistake.
Oh, okay.
I was trying to slide. Sorry.
That's fine. Good thing, good thing that we're not in an auction, because you would have just bought something. Okay. So here we go. The next slide. This is an interesting one, and this is I'm glad that I'm going to bring this up now. A lot of people assume that Medicaid is only for the poor, and it really is only for the poor. However, most people, especially people in New Jersey, where long-term care is very expensive, weren't poor before they became ill. And so here in New Jersey, you can have $500,000, which is a lot of money, and run out of that money rather quickly in a long-term care facility. So the other thing with Medicaid, and the reason actually that when I put this slide up and I was designing this, I put two people on a beach, is because many years ago I was on a beach vacation with a friend, and we started talking about her father, and I told her what I do, and she said, "Oh, my father I would never place my father in a Medicaid facility." And the interesting thing about New Jersey is, as difficult as New Jersey is with a lot of factors, as far as Medicaid, while it's difficult to qualify for Medicaid, Medicaid is accepted in most facilities nowadays in New Jersey. So even assisted living facilities built after 2001 are required to accept Medicaid in 10% of their beds. And most nursing homes accept Medicaid because most people can't afford $140,000, $150,000 a year for very long. So you can receive Medicaid in the finest facilities. So I just want to tell people that is a comforting factor. So if you plan for a future, even if you're not ill now, where you say, you know what, I'm going to provide myself with the option to receive Medicaid and set aside a certain amount of money. That way, as you age, you feel more secure that you can continue to private pay if you want and have the money, or you can choose to have New Jersey pay and stay in the same type of facility. Now, as Randy well knows, most people don't want to be in a facility. I mean, that is not anybody's desire. Everybody wants to be at home. And so imagine planning for Medicaid, but being able to receive care at home and knowing that if you run out of money at home, or if you've put aside a certain amount of money, now you can choose later on whether or not you want to stay home, or if things get really bad, whether or not you should be in a skilled nursing facility, yet you can now afford it. So I see Joy here asked a question. If powers of attorney were executed in another state, do they need to be redone if residence is now in New Jersey? Okay, that's a great question. It's a question that a client of mine asked me last week, as a matter of fact. All these answers are usually a gray area, but yes, powers of attorney executed in another state, so long as they were executed in that state legally, are legal here. The problem, though, is that we have a tough enough time getting financial institutions to accept powers of attorney that were signed in New Jersey and that are legitimate, that I would always recommend when you move to New Jersey, since we're talking about New Jersey, definitely have your powers of attorney and healthcare directive nowadays are saying that if a power of attorney is older than 6 months, they're saying it's stale and needs to be redone. That is not how the law reads. A power of attorney never goes stale. So that's how difficult it's gotten with powers of attorney. And that really started in 2008 with the banking crisis. Every financial institution wants to make sure that nobody out there is taking advantage of the person who wrote the power of attorney or signed the power of attorney. So I would recommend that even if you have a legal power of attorney from another state, once you move to New Jersey, you should definitely re-execute those documents. Sandra, can a person guarantee that they get in a better institution with Medicaid? Not really sure, but I think what you mean is, do they know that if they're on Medicaid, they'll get into a finer institution? The thing is that I'd say about 95% of skilled nursing facilities nowadays accept Medicaid. And Medicaid in a nursing home is governed under federal law. So what that federal law says is you cannot evict an individual who is applying for Medicaid. So if that facility, and when you're moving, when you or your loved one, whoever is moving you into that facility, inquires, one of the questions you may want to ask, if you're willing to accept Medicaid, are they willing to accept Medicaid? And if they're a Medicaid facility, once you run out of money, and I'll put run in quotes because if you've done planning, you haven't really run out of money, they have to accept Medicaid. So they cannot evict you if you apply for Medicaid. So I would just choose the finest nursing home. The thing I always say to my clients is, obviously the paramount importance is picking the right place to live that's going to care for you, because you're going to be there long term and you want you or your loved one to get the finest care. Financials are secondary. So that's the beauty of planning too, because if you take that $500,000, for instance, that you've saved and you put it aside, and after 5 years, you do need a higher level of care, the beautiful thing is you can choose. You can say, you know what, I'm going to go to the finest nursing home in the state, even though they don't accept Medicaid. Or you can say, I'm going to go to the finest nursing home in the state that does accept Medicaid. It depends on where you live. But in Essex and Bergen County, what we find is the finest nursing homes in those counties do accept Medicaid. So it's not a difficult choice. Okay, so this is one for Randy. They pay for home care without adequate documentation. And I see this every day in my practice. People paying for aides under the table. And I don't blame them, because aides are very expensive. Most agencies charge between $25 and $30 an hour. And a lot of times people say, well, I'll just get an aide because this individual is happy with her, or they go on Craigslist, or there's some other way that they're finding an aide. And I don't blame them for saying, hey, we're going to save $10 or $15 an hour because we want to save money. However, it is a very dangerous thing to do for a number of reasons. The first reason is, the reason that an agency charges so much money is because their aides are trained, number one. Number two, their aides are insured and bonded. So imagine that you have an individual in your house picking a senior up to change that individual or to shower that individual, and slips, and now has a chronic injury themselves. They may sue you because it happened in your house. Imagine that an aide is accused of stealing from you. You're never going to get that money back. The best you can do is fire that aide. But an agency is insured against injury, and they're insured, or otherwise known as bonded, against their aide stealing property from the family. Also, what happens if your aide one day decides, you know what, I don't feel like doing this anymore, and disappears, or goes on vacation for a couple of weeks, or is sick? Well, now you have to scramble to find someone else. If you have an agency, immediately the better agencies are going to replace that person. Randy can comment on this, but I'm going to guess within a couple of hours, you'll have someone there replacing that sick or missing aide. But also from a Medicaid standpoint, and I know I keep going back to Medicaid because a lot of times that is the end game for many people. Medicaid requires documentation of any major withdrawals. They look back 5 years, as I said before. So they're going to look through all of your financial statements when you apply for Medicaid for 5 years. And what they're going to see if you have a private aid is $1,000 withdrawal every Friday, $1,000 withdrawal, $1,000 withdrawal, or $1,000 check to cash, or $1,000 check to an individual's name. And they're going to ask, what is this? Your family's going to comment, well, obviously this is the aid that we were paying. Well, prove it. Well, the aid is no longer here. It went back to her home country. She passed away. We have no idea. We had a falling out with her. We have no idea where this person is. And I've seen this firsthand with Medicaid applications. There are certain things that you can mitigate this somewhat, but for the most part, Medicaid does not have to accept that the family is telling them, look, she was ill. This person was caring for her. I had a gentleman come in to do a Medicaid application for his mother about 9 or 10 years ago. Thankfully, this gentleman had money. She had 2 aides. They were both from Poland for 5 years, helping her out, living with her, helping her out, became part of the family. They both went back to Poland, and then he applied for Medicaid because he said, now I don't have anyone. $150,000 penalty. And Medicaid figures that out with a formula, and that meant that she wasn't covered for the first year she was in a nursing home. So she not only paid $150,000 for her care at home, she paid another $150,000 for her care, or her son did, in a nursing home because they didn't use an agency. They didn't keep track of it. So very, very important.
I think one of the other benefits of an agency is that there are people that are supervising that caregiver in the
Right.
home. So in our case, we have, in the New Jersey law says that you must have an RN, a nurse that's overseeing the client and the care of the client. They meet with them between 30 and 60 days, a visit to the home to make sure that the caregiver is doing the right thing. And what happens at Home Watch, we not only have the nurse, but we also have a social worker, because we really feel that the family is impacted, not only the client, but the family itself is impacted. And to meet the needs of the entire family, a social worker and a nurse work together to make sure that the needs are being made.
Right. Also, that brings up another thing is assessments. So companies like Home Watch will do an assessment to make sure sometimes an individual needs a 2-person assist. Now, if you're hiring somebody under the table, they may not know how to evaluate that situation. And once again, you're going to have a mismatch between a smaller individual who doesn't have the training in actually picking somebody up and maybe a larger individual who would normally require a 2-person assist. That's a recipe for disaster. All right, I'm going to go past that one. I just want to say one corollary to the home care discussion is keeping somebody at home or yourself staying at home too long. Now, as I said before, I'm a big fan, and I'll tell you, most of my clients, when they walk in the door, they say, I'm going to die at home. I want to stay at home. This is where I live. This is where I raise my family. I want to stay at home. One of the things that we counsel people on, though, is when is it the right time to leave your home? And what happens is if somebody says to themselves, I never want to go to a nursing home. I only want to be in a home-like atmosphere. If they stay at home until they run out of money, what they've done is they've taken away the option of being able to go to assisted living. So as I said before, in New Jersey, any assisted living facility built after 2001 must accept Medicaid in 10% of their beds. 10% is a very small number. So if you have an 80-bed facility, which is a decent-sized assisted living facility, they only have 8 beds available for Medicaid. Those 8 beds, they go quickly, as you can imagine. And so there is always a waiting list. So what these assisted living facilities have all done, they've done it separately, but I'm sure they're following one another, is they all have created these private pay policies. That means most assisted living facilities in New Jersey will not accept you on Medicaid for 2 to 3 years. So you must private pay, you must move in and pay for 2 or 3 years, depending upon the facility. So that means that if you do want to continue having a home-like atmosphere, at some point when you have maybe 2 years of money left, that's when you have to make that decision. Am I going to stay at home, or am I going to move to assisted living, or am I going to end up in a nursing home because I have no money left and it's the only place I'm going to be able to get Medicaid? So there is a major timing issue. And it's one of the things that my practice prides ourselves on, is that we're not just lawyers. We're lawyers and we act almost like social workers. We treat our clients like they're our own family. And so there's constant communication between our office and our clients, so that our clients feel comfortable calling us for anything, whether that's to ask us for a recommendation for a home care agency or a geriatric care manager or an assisted living facility, or even a financial advisor or another attorney. We really are always there for people. And that's, it's a hallmark of I think, having a great elder law practice where we don't just act as attorneys. So this one also is really important. And this is something that most people do. If I could see all of you now, you might be shaking your head. They add one child's name to their checking accounts, or even to their brokerage accounts, even though they love all their children equally. Now, why did I put that last phrase in there, even though they love all their children equally? Well, here's the thing that most people don't understand. When you own an account, any account, jointly with another individual, when you pass away, that account, by operation of law, automatically becomes theirs. So even though the will says I divide all of my assets, my estate, equally amongst all my children, if there are assets that are held jointly with one of those children, that trumps the will. So it will go to that individual. So let's give you an example. Mom has an estate of $500,000. She has a home that's $100,000 worth of that estate, and she has a brokerage account that's $400,000 worth of that estate. Now, she's concerned that she's not going to be able to make decisions under that brokerage account, or she's not going to be able to withdraw money under a power of attorney. Like I said, a lot of times financial institutions give you trouble with a power of attorney. So she makes her closest daughter, the one who's been helping her out, maybe the one who's living with her now, a joint account holder on that brokerage account. What happens when she dies? Well, we look at the will. The will says, I split everything equally between Jane and John. So John says, good, I'm going to get $250,000. Mom has a $500,000 estate. However, the only thing that John's getting is one half of the house. He's getting $50,000. Jane is getting the $400,000 brokerage account. Now, I tell this story over and over again to families when they come in, and the families who have done this already say, but Jane will do the right thing. Unfortunately, when money's concerned and emotions are concerned, Jane may not do the right thing, because in some examples, some scenarios, Jane moved in with mom, quit her job because mom needed so much care, potentially lost her marriage, is miserable, and all she's doing is saying, but mom obviously wanted me to have the lion's share of the estate because I'm the one who's been caring for her. I'm the one who sacrificed everything. So just be careful how you title things. It's something that we can talk about if you come in, but it's something that you just have to keep in mind. You can talk to your accountant about it as well, that when you're trying to make things easier, sometimes, as I said before, it's like a Rubik's Cube. Things can go awry. Michelle, how much time do I have left?
You can go. You're fine.
Okay.
You're good. I mean, you can go over. We schedule in an hour, but you can go over if you need to. No problem.
Okay. I'm almost done with the slides, and then if anybody has some questions.
Yeah, well, then we'll do questions. If people know how to use the chat button, that's the best way to do it. And then Randy or myself can read off the questions, and you can keep yourselves on mute. If you can't, just if you know how to raise your hand, and I'll unmute you. Okay?
We're also asking if you would put your email address or your phone number in your email address so that we can send you materials afterwards. If you have additional questions, we have put ours in the chat room as well.
Okay, so my if you scroll up in the chat box, I put it in on top. I can put it in again for those who can't see it, but my email, phone number, and name at the top, 1:27 p.m. This slide talks about veterans benefits. I'm not sure how many people here are aware that there are what's called non-service connected veterans benefits. That means that the individual did not have to be disabled due to wartime. They just had to serve during wartime. Serve overseas, they just had to serve during wartime and be honorably discharged. If that is the case, when an individual starts needing assistance, they oftentimes receive up to $2,400 a month from the VA. Even the widow of a veteran can receive up to, I think it's now $1,400 a month. Goes up every year. So it's really important, and people very often don't know about it. The first time people usually learn about it is when they're touring an assisted living facility, because elder law attorneys have done a lot of seminars at assisted living facilities, and now the sales force there recognizes that it's a great way for people to help people pay for their care in assisted living or in a nursing home. The problem is that people don't secure it early enough. I've seen people who have been in assisted living for 7 or 8 years, and they would have qualified much earlier. So they've given up over $100,000 worth of benefits that they could have received. Finally, they fail to seek professional advice. And, I keep talking to you. I know it sounds self-serving that we are a full-service elder law firm, that we provide not just legal advice, but we provide referrals for other professionals. But it's true. What we find very often, if we go back to slide 1, when I talked about the house, you always have to be aware that you need to talk to the right professional, not just a professional. What we find with a house, for instance, is, well, how did somebody transfer that house to their children and make such a potentially disastrous mistake? They went to a general practitioner or a real estate attorney and said, hey, I want to transfer my house to my children. That real estate attorney or general practitioner, they did their job. They did as the client wanted, but they never asked the other questions, which are, well, gave enough information. Well, do you realize that there are all these potential negative implications of it? So I always find it interesting that the individual who comes to my office has already sought legal advice in the past, but they didn't seek the right legal advice. They just sought somebody who could do what they asked that person to do. We never just do what someone asks us to do because we're the professionals. We advise them on how they should do it correctly. So Ricky's asking, what documents do I need to keep from real estate closings? I have one from New Jersey, one from New York, and one from BC. Question. Well, if we're talking from just a record keeping perspective, I would say keep up to 7 years. If we're talking about from a Medicaid perspective, they only look back 5 years. So long as it wasn't done in the last 5 years, from a Medicaid perspective, you can dispose of them. Nowadays, I'd be less apt to dispose of anything. You can easily take a photo with your phone, or if you have a scanner at home, you can scan it into your computer. Or what I just discovered is the iPhone has a great scanning feature now in the Notes app. And so you can just scan things and email them or send them to people. And it looks just like the document. Okay, so Jeanette, is it okay to add your child's name to the house? Does that change anything? Well, just like adding your child's name to a brokerage account, it becomes that child's upon death. So if it's your only child, or if you want specifically that child to inherit at death, then that might be something that you want to do. However, just know that when you own something jointly with someone else, you do share certain liabilities with them. So if they are sued, I would imagine that their creditor or somebody suing them for a personal injury would probably go after that house. I don't see why not. So you have to be very careful when you're titling assets in someone else's name. Annette, let me just make sure I didn't forget anyone there. Can I make someone an executor of my will without their knowledge or signature? Yes. So you do not, you can always put an executor, or in New Jersey, you can put an agent under power of attorney or representative under a healthcare directive without their knowledge or consent. I wouldn't recommend it though. So in New York, the agent is required to sign that they consent to being an agent. I think it's a great idea. You do want somebody who's responsible and willing to do it, because the executor could renounce their executorship and say, I don't want to do it. And that could create other problems. Let me just,
Jackie and Perry have a question.
yeah, I see. I'm just, oh, there it is. What are the financial limitations when applying for Medicaid? Okay, so in order to apply for Medicaid as a single individual, you can have no more than $2,000. For a married couple, the applying spouse can have no more than $2,000, but what they call the community spouse, the spouse that's not applying, can have approximately $130,000, but it's no more than one half. So the way that the rule is written is the community spouse can keep one half of the assets, $130,000. So if they have 500,000, they can keep up to 130. If they have 200,000, they can only keep up to 100. Okay. If you own the house, wouldn't that put you over the limit? How do you get around that? Okay, that's a great question. The house is an exempt asset for Medicaid, as long as you're living there. That's why I like to move the house into the trust 5 years prior to a Medicaid application, because even if you have a married couple and you say, okay, well, one of us is going to be living there, well, that's not always the case. The one spouse could pass away, and the other spouse has to move into assisted living or a nursing home, or both spouses move. There are many scenarios where somebody will not end up living in that house. So as soon as somebody moves from that house, it's no longer exempt. It has to go on the market. And once it's sold, that individual will have to spend all that money down. Lori, can you briefly discuss the impact of the CARES Act on inherited IRAs and what seniors should do now to keep their options open? I mean, that could be a seminar in itself. But the CARES Act on inherited IRAs, an IRA up until the CARES Act was passed could be stretched, what they call stretched, to a spouse or to another beneficiary. And when I say stretched, it means that what they do is the required minimum distributions, the amount that must be taken every year, would be at that individual's life expectancy. So if, let's say, a 40-year-old inherited the IRA, the payments would be stretched out over approximately 50 years, their life expectancy being around 90. Now, due to the CARES Act, the stretch to a spouse is still the spouse's age or life expectancy, but to a child, it's 10 years. And so that's going to change some of the planning. One of the things that I tell seniors to do is, as soon as you have a medical expense that exceeds 7.5% of your adjusted gross income, which doesn't take much, 7.5% isn't a whole lot, then you can take what's called a medical expense deduction. Once you can take a medical expense deduction on your taxes, and this is something to discuss with your accountant, that's when I would start using the IRA more aggressively. Because whenever you take money from an IRA, it's income. And a medical expense deduction offsets income. So if you can, you want to spend down your IRA as much as possible during life in a tax efficient manner so that your children don't get hit with a huge tax bill later on after you pass away. Let's see. The next one is, my sister and I own 3 houses in both our names. I have 2 sons. She has no heirs. If I predecease her, will she become sole owner of the 3, even if my family? Okay. That all depends on how it's titled. So if the 3 houses are titled as joint tenants with right of survivorship, they will bypass the will. Okay. It will go to the survivor of the 2 owners. If it's titled as tenants in common, that means each one of you owns half the house, and we look to the will now. Where does it go? Both of them have their pitfalls, because if you want your will to control, does your sister, for instance, if you die first, want to own these 3 houses with your children? That might create some other problems. So there are always positives and negatives to each situation. Sandra, I'm single, no children. What considerations might I need to especially consider? You don't own a home. Well, you want to make sure that the discussion really is, who do you want to leave your estate to, number one. If your question is about dying, if you leave your estate to other people, they're going to pay an inheritance tax. But then again, it's kind of a windfall to them because they're not your children. If you leave your estate to charities, then there's no tax owed, and it's a great thing to do. If you're talking about planning for a long-term care need, you want to be very careful about who you choose to be your power of attorney, your healthcare directive, your healthcare directive, representative, and if you want to protect assets for yourself, who you want to be trustee of a trust. Those are all very important considerations. Sometimes you might want to hire a professional to do that. Other times you have really good friends who may be younger than you, or an accountant that you really trust, or an attorney that you really trust to do that for you. All right, I think that's it. We came in right on time. Any other questions? All right. Thank you again. This was a fabulous opportunity for me, and I really appreciate everybody tuning in. And once again, congratulations on mastering Zoom technology. It's a great thing. Michelle, you there?
I am here.
Thank you, Michelle.
So much,
thank you
Eric.
very much. And Randy, thank you.
So if anybody has questions for Randy or for Eric, you can scroll on the chat and you can see he left both of the Randy and Eric both have their contact information. And if you'd like, if you just want to email me, that's fine, or you can leave your email and I can just forward that to you if that's easier for you. If you can't find the chat, I can give you their contact information if you want to reach out if you have very specific questions. I think there's, is there any more? No, there are no more questions. Okay. That's great. Thank you so much. This was terrific. Eric, where is you're working virtually now. So are you doing Zoom consultations?
I'm doing Zoom and phone consultations. We are now doing signings in person for the most part. even though the state of New Jersey has allowed us to notarize remotely, I think that could create problems down the road. So I'm coming, ideally we'd like you to provide witnesses for us, but we are glad to have 2 staff members come with me. One of us can notarize, 2 witness. We come in masks. If the weather is good, we do it outside, ideally, and stay 6 feet apart. So we just watch you. What the ideal situation is, you set up a bridge table in your garage and you sign your documents while we're standing outside. You back away and we sign our part.
Wow, what a world, right?
Yeah, what a world. But, we have to be creative during this time. And the Zoom meetings, I think, are just as good as, it's never as good as in person. But the Zoom meetings are fine, and you can get a good idea of whether or not, you're dealing with a good person, I think.
Yeah. Yeah, I think for people that are putting things off, I know a lot of the questions, a lot of the comments that you made in your slide presentation are sort of about pushing off that discussion of death and dying, what's going to happen. I know my dad is one of those people who just doesn't want to talk about that. So let's just change the subject. But it's something that, really can create problems down the line if you don't set things up correctly. So this presentation will be televised on our channel 34. I don't know when, but if I get a date from our programmer, I will send it out to you. So if you wanted to watch it again, you can watch it. You can also watch it on YouTube. It'll be available probably within a day or 2 on YouTube. And that's the YouTube and Lifelong Montclair. If you go to Lifelong Montclair, YouTube will come up, and you can watch any of our videos that we've recorded on that at your leisure. So
Rick, you have another question there.
Yep.
Yeah, I was about to answer by chat, but
Yep.
Okay, so my consultations are an hour long, and you can ask any question you want, and we'll let you know the answers to those questions and how we can help you.
Great. Thank you so much. This is
All
great.
right, thank you.
Thanks again, Randy.
All
Bye,
right,
everybody.
my pleasure. My pleasure. Thank you, Eric, and thank you, Amy, and thank you, Michelle, for giving us this opportunity. We hope to do more programs together with you.
Wonderful. Looking forward to it. Thanks again.
Thank you so much.
Take
Bye,
care.
everyone.
Bye.
Bye-bye.